I would advise anybody to seek an attorney before you add somebody to your title that's not your spouse. We had a file where a guy added his kid to title because he wanted to prevent his kid to go through probate. This gentleman was a widow and he had one kid. So he thought the best thing to do would just add my kid to title, and that way when I pass away, it goes directly to him. On the surface level, that sounds like a pretty solid idea, but it wasn't, because over the years, that kid started getting into trouble. And not like trouble, like little trouble, like running from the feds trouble, like really big drug trouble. And then they went through trial, and then the judge and the jury agreed that he's in bad trouble. And then since this kid was on that house, they seized that asset. They froze the dad's bank accounts because the dad added the kid to everything. So his bank accounts are frozen. He couldn't sell his house. His car was seized. Everything. Because since that kid had ownership of it, all of that was fair game. Then after talking to the Kansas Bureau of Investigation, the IRS, the FBI, too many acronyms, alphabet soup type of stuff, this guy's attorney showed the government what this guy was trying to do. It wasn't the kid didn't own it. The dad was just trying to do this. And then he got permission to sell this property. But this property had to be cut out of the judgment that was going against this kid. So anything that's attached to anybody that's on title could potentially attach to your house. That's why a beneficiary deed is probably the best scenario for you, because they get the property after you pass away. You avoid probate, and they're not on title right now, because you can add somebody to title, but you can't remove them. They have to do it, or the government.